everything set up here. Okay, welcome, evening, everybody. This is Brad Micklin. I welcome you to this month's webinar called The Wonderful World of Trusts. This webinar is going to be co-sponsored with Michael Feinfeld, an attorney in New York, who concentrates in estate planning and trust work in New York. The reason we're doing the co-sponsorship is they are his firm and he handle New York cases, I believe, and don't do New Jersey, where I'm just the opposite. And I often have clients who need help in New York, and I'm sure they vice versa. So we thought this would be a good way to sort of help both of our clients at one time. For those of you who may have attended these webinars in the past, we're scheduled for an hour tonight. Michael and I looked at the material and talked about it. We probably think this will be a little bit shorter than most. We're going to hit topics from a broad standpoint, which makes for a lot less. Any of the individual topics could probably be an individual webinar in and of itself. So we're going to try to keep it simple and straight to the point for you. This is a one-way communication, so you can hear us, hopefully, but we cannot hear you if you were speaking. There is a control panel should be on the right-hand side of your screen where you can post questions. I will check periodically through the webinar to see if we have any questions because they don't appear right on my screen, but I can open them up if I take a second, and we'll try to address questions as we go. We are also recording this webinar so that if you'd like to get a copy of it emailed to you, we'll send one after today's webinar, and then if also you have any questions. With that, we're going to move along into some quick introductions. For those who have not met me, this is me, Brad Micklin. I'm the managing member of the Micklin Law Group. We are a law firm in Nutley, New Jersey, concentrated in divorce, family law, and estate planning issues. I began my career clerking for a judge in Bergen County in the supervising special civil part. From there, I went and did complex commercial litigation with Kessler & Associates in Clifton, New Jersey for a couple of years. Found I didn't like representing companies. I like dealing with people, so I opened my own office in 2001. In that time, I opened as a general practice attorney, which means I did a little bit of everything, but quickly learned you can't be good at everything, so I concentrated my practice into divorce, family law, and estate planning, which is the areas that the Micklin Law Group concentrates in now. I handle more of the complex and high conflict divorce, family law, and estate planning cases. Next, I'm going to turn this over to Michael, who'll give you an introduction about himself, a little background.
Sure. Hi, everyone. Good evening. My name is Michael Feinfeld, and I'm a co-presenter today for this presentation of The Wonderful World of Trust. So on behalf of myself and my colleague, Brad Micklin, we welcome you and thank you for taking the time to be here. Brad and I look forward to sharing what we know about trust and estate planning and hopefully helping you and some of your clients resolve some of the issues that you might have. Just a little bit about myself. I'm a graduate of the Benjamin M. Cardozo School of Law here in New York. I received my undergraduate degree from the University of Rochester and my master's degree from the University of Chicago Trinity School, both degrees in the area of religious studies. But for the past 9 years, and I've been an attorney, over 8 of which have been focused almost exclusively on one practice area, that's trust and estate. So I've worked on dozens of matters and reviewed hundreds of documents in support of my clients. And what I think I add, the greatest value to my clients is my commitment to really listening to them and using my legal knowledge and background and experience to structure their estate plans to meet their goals and aspirations. I want to thank you all for taking the time to listen here today. Every process begins with a first step, and by being here today, you are taking a meaningful first step towards resolving your specific challenges or the challenges of your client. And while we may not answer everybody's questions here today, please know that we are available for questions. And if you or yourself or one of your friends or your clients would like to speak with us, the Baltimore Group offers free 30-minute consultations, and we'll be happy to sit down with you one-on-one to answer your specific questions. So, without any further ado, let's get right into it.
Okay. Before we jump into the first portion of this, I'm going to ask if anybody or whomever is listening just to type into either the questions or the chat panel on the right side of your screen so that I know you can hear and see our presentation. Anybody?
Okay.
All right. Is anybody that's okay? Now I got question marks. All right. I got one person said hello. I'm trying to make sure that everybody can hear me and Michael, I'm sorry, and also see that Michael's um, background is listed on your screen. Can you see that? Does somebody just type yes? So if one person can, usually everybody can. All right. I think everything is good. Great. I
Right.
will try to monitor this as we go through because I'm going to primarily let Michael do most of the talking since this is really going to be his webinar about New York, and I'm going to chime in from time to time about differences that may occur in New Jersey. If there's a change in whether you can hear or see, just type into that chat panel so we can go and I can address as we move along. And like I said, also I'll try to check from time to time for any questions. So without that, let's move on. Michael's going to give you just a brief overview of what to expect today.
Yeah, so let's talk a little bit about what we're going to be talking about today. I think there are basically three things that we want to focus on today. The first one is understanding how trust and estate trust work in estate planning here in New York, but also Brad will hopefully chime in with some stuff about New Jersey as well. And then primarily getting rid of the idea that trusts are only for wealthy people, because trusts can do some powerful things for people that, don't have unlimited quantities of wealth. So, and then exploring in particular what the different aspects of what a trust can do for you and for your client. So, I mean, with that in mind, you want to think about, trust as a vehicle that can benefit everyone, really. It depends on, how much you have, obviously, and what your client's specific situation with regard to, how useful a trust is going to be to you or your client. But the important point is that trust in the right situations can benefit everyone. So moving right along.
I usually tell my clients, people tend to think of trust as this big fancy thing that only banks can handle and it's very expensive and costly. And it's really, it isn't. It's more of like what I call legal fiction. I equate it to a corporation. Everybody knows that person who, started a business in their basement. They followed a corporation online and they're operating. And that corporation exists, but it's not like a McDonald's. It's just sort of on paper for protection, tax protection, liability protection. A trust operates in the same sense. So if you think of it along those lines, you'll realize that they're not as complex and scary as most people think. So next we're going to
No.
talk. I'm sorry, Michael.
I just wanted to echo that. I mean, you hear about, trust fund babies usually and people who, live off of their trust. And, there are certain segments of the society who do that for, but a trust can be very valuable, as we'll see, in just protecting ordinary people, in certain situations and with their lives. And certain people who have certain needs in particular that need to be met by, and they can only be really met by having special arrangements like a trust.
We have a question up here. It says, are there different laws in Pennsylvania and Florida as it relates to trusts? I'll jump in here first and say first, I don't know for sure. While I'm licensed in PA, I don't practice in PA. I'm going to assume all states will often have some particular laws about different taxes, trust planning. Florida is a very specific state when it comes to creditor protection, so I would assume that there are possibly more unique laws regarding trust and how they protect the individual grantors of them, but I really don't know anything specifically. I don't know about you, Michael.
Yeah, well, I think that's true. There are certain specific aspects of the trust of trust that can vary from jurisdiction to jurisdiction. So Pennsylvania and Florida, and yes, there are certain issues with Florida providing safe haven, but I think that's primarily though with regard to homes and stuff like that. I mean, their probate system is a little different, I think, in that in that it sort of encourages, as we'll see, revocable trusts to avoid probate. But in general, I think a lot of what you can take out of our webinar here today can be applied across jurisdictions, because we're going to be talking more generally about trusts. I mean, obviously, when you get down to the more granular aspects of establishing a trust in a particular state, then you'll have to employ an attorney who specializes in planning and administering trusts in that particular state. But just in terms of overall what you're going to get at, hopefully what you get out of today's webinar, you can take most of this, because I think it applies across jurisdictions.
Right, I would agree. All right, so let's turn and talk a little bit just about basic estate planning and the documents that are usually entailed in one.
Yeah, well, I mean, in focusing on what I call the basic building blocks of estate planning, these are the things that everybody should have. We'll talk a little bit about, there are generally 4 documents that I usually advise clients to have: your will, your living will, your healthcare proxy, and your durable power of attorney. Your will obviously is a document that speaks for you at death and disposes of your property at death. The living will, which states what you want in certain instances of end-of-life situations, if, for example, you are on life support without any reasonable expectation of recovery. And a healthcare proxy, which appoints an agent to make healthcare decisions for you in the event that you are unable to. So it could just be, just a short stay in a hospital, like, for example, if you had to get surgery. The healthcare proxy, the person you appoint as your healthcare, allows you to appoint somebody as an agent to talk to your doctors while you're under the knife, for example, if you're getting surgery. Or even in a situation where you have Alzheimer's or something like that, or a debilitating disease, then the agent can make your healthcare decisions for you that way. And then the power of attorney, that's generally for allowing appointing an agent to perform your business in the event that you're unable or not present to perform it. So they can do things like talk to your mortgage company, talk to your credit card company, do your banking for you, even sell real estate for you, do a real estate transaction under a power of attorney. And these are all important aspects of an estate plan, because they cover all of the situations that you would need. You have your document that speaks of death, your will. You have your document that talks about what to do in an end-of-life situation. You have your document that deals with you when you're in the hospital, and the healthcare proxy, and your durable power, which allows somebody to do your banking for you. So those are the 4 basic documents, and then smack in the middle of all these things are trusts. And trusts can be a standalone document, or they can appear in wills, as we'll see. And if you've ever wondered whether you can combine the benefits of all of these 4 instruments, the power of attorney, the healthcare proxy, the living will, and a will in one document, I'm going to tell you how you can at the end in a special kind of trust. So all of these instruments, they all form the basics of an estate plan, and they cover all of the aspects of a transition in a person's life. And I think that everyone needs them. I would say everybody who has anything or a family or somebody that they want to protect, or something that they want to pass on, should consider having these basic documents.
Right, I agree. I tell my clients the same thing, because people often think that either they don't have enough money that's of an issue, or their kids know what kind of medical care they'd want. But the problem becomes, and we may get to touch on this a little bit, but it's more outside of the scope of what we're talking about. The problems created by a lack of planning can be very devastating to families. Usually, not only are there significant costs associated to trying to determine issues when there haven't been proper planning documents, but it's also at a time where they're usually dealing with some kind of tragedy, like the loss of a family member's life or a severe medical injury that hospitalizes somebody. So they're already dealing with a troubled time that they don't need to have any other burdens, and providing these documents to them in advance will make sure that there are no complications at that worst moment of time.
Yeah, and I mean, you think about these things very concretely when, for example, somebody's diagnosed with an illness. For example, in my own life, my father was diagnosed with cancer, and he died 6 weeks later. But because he assumed that he had finished his planning, we had to scramble around at the last minute to try and make sure that he had up to date documents. And while, fortunately we were able to accomplish most of the stuff that we needed to do while he was still alive, there were still a couple of things, a couple of loose ends, which it would have been better if he'd taken care of, if he focused on more specifically while he was alive. So yeah, this is something you don't want to wait for, but yet a lot of people do because they're worried about things like, waiting, like, well, if I don't have enough to need to do this estate planning, or if I make something I hear a lot actually is, if I make my will, that means that I'll die sooner. That is often a fallacy that I encounter, and it's almost impossible to combat that because you can tell your clients that they need to do their planning, but unless they're keeping up with it, sometimes it's very hard. So moving right along, let's talk a little bit about the differences between a will and a trust.
Actually, before we get to that, there's a question: is how do trusts maintain privacy when elderly trying to qualify for long-term housing and care, i.e., look-back periods? Probably referring to like Medicaid issues.
Yeah, well, I want to deal with that. We're going to deal with that a little bit further on. So if I could table that particular question, because I do intend to deal with the look-back period for Medicaid. But I wanted to talk a little bit about what constitutes a trust and the differences before we get into the specifics. But I promise I will address that question a little further on.
We'll move on to the differences of wills and trusts.
Yeah. So let's talk a little bit about it. I intimated as much what is a will. A will is a document that becomes operative at a person's death, whereupon it sets forth the creator's, what's also called the testator's wishes, with regard to who they want to get their property when they die, and it appoints the beneficiaries of their estate, and then it appoints somebody to manage their estate, their executor. So that it's an important fundamental distinction that I want to drive home here today. The will is an actual document, okay? A trust is an arrangement. It's a legal arrangement which establishes a relationship between an individual who's designated by the creator, or as Brad called it, the grantor sometimes, or the trustor. There are various terms for the person who creates the trust. And the individual who he or she appoints to hold the property, the trustee, that hold the title to and manage the property for the benefit of another person, a beneficiary. Okay, so that the trust is that legal arrangement. You have a trustee who holds title to property for the benefit of another. And as I mentioned before, there's a distinction. Unlike a will, which is the legal document which speaks for the person, a trust is an arrangement. This means that you can create a trust while you're alive, whereas you can execute a will while you're alive. It does not become operative until after your death. And the trust can manage and distribute property for you while you're alive, or afterwards when you are deceased, or as I have in the slide, worm fruit. But that is an important distinction between a will and a trust. A trust holds property for other people, and it's managed by the person who's designated as the trustee. And the trustee has an important relationship between the property and the beneficiary. They have to hold it and manage it and distribute it or not distribute it according to the wishes of the creator, which is usually set forth in a trust instrument. And they have a duty to do this with the utmost care on behalf of the beneficiary. So they can't take the money in the trust unless they are the beneficiary, I guess, the trustee, and put it into their own pocket or use it to enrich themselves or increase their business opportunities, unless, of course, that's specifically what the trust is created to do and it states that in the trust. But generally, the trustee has what's called a fiduciary relationship, a fiduciary responsibility to act on behalf of their beneficiary. So it's an important device and an important relationship which basically allows a person to establish a third party, in other words, to impose a third party to basically help manage the property for the benefit and distribute the property for a beneficiary.
Now, Michael's also speaking mostly on the benefits of trust, which is obviously the topic, but don't lose sight of the fact that you probably will need to have both, even if you're putting all of your assets into a trust. We're speaking of the benefits of a trust, but usually when I have a will, even if it's just as a backup in case there are assets that are accidentally not placed into a trust, or to sort of mirror what's called a pour over trust so that it goes into the trust. But we're not saying that you don't need a will if you have a trust. It's just the trust is a much more effective planning on many different topics.
Yeah. Well, I mean, a trust can also be a part of a will, as we'll see in a minute. I mean, the trust is the legal arrangement, and it can be in several forms. So it can be part of a will, or it can be a standalone instrument, and that's an important distinction as well.
Okay. All right, so let's take a quick look at some of the differences between wills and trusts. A little more information.
Yeah. In particular, one of the things that you have to do when you have a will, if there is property that is going to pass under it, meaning that theoretically, in an ideal world, you could create a situation where you didn't actually have to, where you had a will, but you didn't actually have to probate it. If everything was titled to pass to beneficiaries by operation of law. So, for example, if you had an account and you had a transfer on death designation or joint tenants with rights of survivorship, that could create a situation where if you titled all of your assets that way, all your real property passed to the surviving spouse as tenants by the entirety, that sort of a thing, then you could create a situation where you didn't actually have to use the will. But for the most part, most people don't do that specifically. So in order to make the will operative, it has to be, I guess, blessed by a court. So you have to take it into the court of in New York, at least, of where the person is domiciled, with a request that the court review the will and grant and appoint the executor if the will is executed properly and is in order. So it's a public process where you have to tell the court what is going to go through probate, what are the assets that are going to pass under the will, and it takes a lot of time, and possibly it costs a significant amount of money, particularly if somebody doesn't like the will, and the heirs want to contest that. And also, it doesn't provide any control over the assets for the creator while they're alive, like, for example, in the case of a disability. And also, if you have property out of state, you have to take that will after you probate it in the jurisdiction where the person is domiciled, and go to the state and put the place where they had that property, and then probate the will in another proceeding called an ancillary probate proceeding in order to get that property to pass under the will. So if you have, for example, Pennsylvania real estate, like one of my clients do, after I get their will probated here in New York, I'm going to have to take their will to an attorney who's a friend of mine in Pennsylvania, and along with a copy of the entire probate file here in New York, and get it and see if we can transfer the property into the surviving spouse's name. For a trust, if, for example, you created a revocable trust or an irrevocable trust, and then there would, while the grantor, the creator, was alive, then there would be no probate. If there was of the assets that are in the trust. No probate of the assets that are in the trust, and that's an important distinction, because if there are assets, as Brad pointed out, outside of the trust, then you still have to probate some sort of a will, or use some sort of an administration proceeding to dispose of those assets. But for whatever's in the trust, you wouldn't have to probate that. The trustee would manage it or dispose of it according to the terms of the trust. It's private, meaning that you don't have, it's not a public process. You don't have to, unless there's a dispute or something, You wouldn't have to disclose what's in the trust, and there would be no delay if, for example, the creator of the trust died, and the successor trustee or the trustee who was managing the trust, they will just go on with the trust and manage the assets. And also, you can build in provisions for control of the assets with the creator, the grantor becomes disabled. So there's a lot more control, there's a lot more privacy with a trust than with a will, and potentially it could save you money if you have a lot of assets and you have certain family issues. Say, for example, if you have issues with a spouse, and you didn't want the spouse to receive all of your assets, you could theoretically put some of them into a trust for somebody else, and presumably, the spouse wouldn't really have much to say about it. For example, if you did it with your separate if you did it with your separate property, not your marital property, or then presumably then it could pass through your will without your wife having your spouse or having too much to say about it. So that's an important distinction between a will and a trust, and it shows you the real power that a trust can have that a will doesn't have. Another example is you can have some sort of creditor protection. I met with some clients today, some colleagues today who run a trust company that runs Delaware Asset Protection Trust. And if you set those up in the right way, you could protect the trust assets from creditors, from litigants, and that sort of thing, in a way that you can't with a will, because with a will, it's a public process, and you have to give the creditors the ability to make their claims within 6 months, I believe, of probating the will, offering the will for probate.
There's also one more point that didn't make its way to the PowerPoint. The benefit of a trust is that it avoids will contests. Wills can be challenged for many different reasons, and I don't know about Michael, but I've seen a big increase in the number of people who are challenging wills. I think partly because it's a popular buzzword and it's easy to research on the internet, and secondly,
Right.
because legal fees are often paid out of the estate, so there's little downside to somebody who wants to make a challenge, even if it's a weak one.
Yeah, no, that's correct, because in New York, for example, they allow you, even prior to having to object to the will, they allow you to depose the attorney draftsman of the will, and also the witnesses to the will, to make sure that it was executed properly.
Right.
So there's a lot of opportunity with a will and its public process to challenge it, whereas there's less opportunity, we'll say, with a trust. I mean,
Right.
You can still challenge a trust in certain instances, but it's much, much harder.
Right. All right, so let's talk about the different types of trust for a minute.
Yeah, okay. And I alluded to this before. I'm going to talk about this 4 equals 3. Technically, there are 4 types of trust. There's a living trust, which is also called an inter vivos trust. That's a fancy Latin word, and that's created while the creator, the grantor, the trustor is alive. There's a testamentary trust, which is created by a will, and it becomes operative at death. And then there's what's known as a revocable trust, meaning that the person can revoke it. And the creator, that basically is a trust where it's essentially the alter ego of the creator. They maintain control of the assets, and they can change and alter and restate the trust at any time. They can take all the assets out of the trust generally while they're alive if they're the trustee, which most people, when they set up revocable trusts, do. And it allows a lot of control while you're alive. But when you die, when the creator dies, then it becomes the 4th type of a trust, which is an irrevocable trust. And an irrevocable trust can be created. The grantor basically transfers, the creator transfers assets to the trust, which is not, they can't revoke the trust, and they generally have less control over it. Although in certain instances under New York law, an irrevocable trust isn't completely irrevocable. because if you get everybody's permission, you can alter the terms of the trust under New York law, meaning if you get the permission of the trustee, the grantor, and the beneficiaries, you can alter it under New York law. But generally, it's irrevocable. Usually, irrevocable trusts are set up for tax purposes to get the trust, the property that's transferred to the trust out of the creator's estate. And that was much more important when the estate tax rates were lower, although it's still kind of important in jurisdictions like New Jersey, where I believe the estate tax is under $1 million. The threshold for estate tax is under $1 million. Is that correct, Ray?
Yeah, it's 675.
Yeah, 675. So that could still potentially be important, for example, in New Jersey. But in New York, they are in the process, but it can also be important in New York because they're in the process of raising the estate tax exemption to meet the federal exemption, which it will in 2019. But if you're over 5% of the estate tax exemption, then you get no estate tax exemption. So if the amount that you have in New York is over, currently it's $5.43 million. If it's 5% over that, so 105% altogether, then you get no estate tax exemption, and it's the highest rate in New York, which I believe is 16%. So that's one of the reasons why irrevocable trusts are created. But anyway, this is how 4 equals 3. There are actually only 3 types of trust. There's a revocable living trust, and an irrevocable living trust, and a testamentary trust, which is irrevocable when the creator, the testator, dies. So that's how the 4 types of trust become 3. So those are the basic types of trust. And every other trust that you hear, whether it's a fancy type of gifting trust, like a grantor retained annuity trust, or something like a life insurance trust, or whatever, it's all one form of these 4 trusts: a revocable, an irrevocable, or a testamentary trust. Those are the basic types of trust.
Yeah, there's a slight difference with New Jersey when it comes to revocable trusts. Michael was saying that in New York you can dissolve or revoke by consent. I don't believe you can in New Jersey, but you can seek to dissolve an irrevocable trust if the purpose for which the trust was created either no longer exists or cannot be satisfied. Like, for instance, you transfer assets to provide for somebody's education, and they finish their education. So the purpose of the trust no longer exists. You can file a motion with the court, and the court will dissolve the irrevocable trust. And now a lot of people are concerned about that limitation and the loss of control over assets. So what I usually advise when you're drafting one is to have provisions that allow you great control over replacing the trustee or the person that you put in control of the fund. So if you're transferring assets to an irrevocable trust and you're concerned about losing control, especially elderly clients often have a concern about losing control of their assets. As long as the person that they put in charge of giving them their assets back in controlled payments under the trust, if they have power to replace that person easily, then they really don't lose any control. You just want to always make sure you have a friendly trustee in place.
Yeah. The other thing that New York allows for irrevocable trusts and revocable trusts, although you don't need it for revocable trusts usually, is decanting. Does New Jersey allow that? Decanting, what that is that means that you could take the trust assets and put it into, if you have certain powers, like the power to make unlimited, if the trustee has unlimited power to make distributions of income and principal to the beneficiaries, you can then they have the power to take the assets out of a revocable trust, one that they can be revoked, and put it into a new type of a trust instrument.
Right.
Is that available in New Jersey too?
Yeah, as long as the trust document provides for it, because it's almost a common sense approach to it. Because if they could take all the money out anyway, then there's no protection that the trust was intended to provide in the first place.
Yeah. Yeah, well, in New York, I think it's by statute. So, I mean, it doesn't necessarily have to be in the trust document itself, unless the trust document specifically prohibits it.
All right, so next we're going to look at some of the things to do with a trust.
Yeah. So, as I mentioned before, once upon a time prior to, we'll say, 2013, the irrevocable trust for most people were used for estate tax planning. And in New York in particular, it was particularly important because we had an estate tax threshold of $1 million. So anything over $1 million, which you can get to pretty quickly if you own a home, for example, in Manhattan or something like that. You know, you have a few brokerage account and an IRA, and you pretty much, you know, even if you have, you know, minimal amounts in those, generally you're going to get over the threshold pretty quickly. But since they changed New York law to try and match it, now I think the state tax threshold is $3,125,000 or something like that currently, and it's going up to the $5 million plus. Yeah, that was as of April 1st, 2015. It's $3,125,000 in New York. But the federal exemption amount is, as I mentioned before, $5.43 million in 2015. Irrevocable trusts were perfect means for transferring property out of an estate owner's estate. So irrevocable, the only thing that you had to worry about with that is obviously gift tax. But you have, you know, a high, if you work it out and properly, there are ways that you can transfer property out of your estate with minimal gift taxes or minimizing gift taxes. Either it's by using, for example, your annual exclusion, your ability to give $14,000 or $28,000 if you combine that with your spouse to anybody in a year, or there are other ways that you can, by giving, you know, minority gifts and things like that. There are ways that you can lessen the amount of the gift. So that was very common among, you know, people even of modest wealth, a way of reducing their overall estate taxes. Was by transferring property to irrevocable trust where they gave up control, and they would also have to give up any ability to have use or control over the assets in that instance otherwise under 2036 of the Internal Revenue Code that would come back into their estate. And so that now that they raised the estate tax exemption amount, the federal amount, to over $5.43 million, it only affects 0.18% of estates that are filing state tax returns, I believe. And the focus now is on income tax planning for a lot of people.
And Mike, I want to jump in here for 1 second while you're talking about tax issues, because the question was posted. When a trust is created for real estate assets, are there tax consequences, transfer taxes, recording fees, etc., as a real estate deed is updated into the name of the trust?
Well, there can be, depending on how much is transferred, how much of the property is worth. As I mentioned before, you can transfer up to $28,000 if you combine it with your spouse, or $14,000 every year to a specific individual or individuals. So, I mean, there are potentially you could, if you had enough beneficiaries of the trust, and they had a right to, like, we'll say, make use of the trust assets, you could use that. And actually, there was a recent case in the tax court, I think this year or last year, called the Micklin case, where they transferred, where a grantor and his surviving spouse transferred over $3 million in assets to a trust that had over 60 beneficiaries. And some of that was real estate, and they basically were able to reduce their gift taxes very significantly by using the ability to use what's called the annual exclusions for gifts. So yeah, the answer is yes. If you transfer, there will be a estate and gift tax effect if you transfer property to a trust. If you
also a couple of,
I'm sorry, if you transfer property to an irrevocable trust with the goal of getting it out of your estate, then you have to survive 3 years also after the transfer, or that gets included back in your gross estate too. Sorry, go ahead.
Yeah, a couple other things to be considered if you're going to be transferring real estate into a trust or into a REIT. One is a potential capital gains issues, always talk to an accountant, but also in New Jersey, if there's a mortgage, you have two issues. One, we have a realty transfer tax, which is a certain percentage of the outstanding mortgage. So if you're just transferring the deed for asset protection and you have a substantial mortgage, you may trigger a substantial realty transfer tax. But also, there's going to technically be a default clause in most standard mortgages that say if you transfer title, you can trigger the prepay or the repayment of the entire balance due. Now, most of the time, if not nearly all the time, that option is never exercised by the lender because they don't want the property, they want your payments, but it is a risk and it's one that you need to be aware of if you're going to be doing that kind of a transfer.
Yeah, you should definitely, if you're thinking about doing that sort of a transfer, you not only need to do it with an attorney, but you need to have your attorney contact, particularly if you have a mortgage. It's probably better not to do it with property that has debt on it, because you can trigger all sorts of tax issues on the federal side too, depending on how much the property is worth too. But you definitely want to get permission of the lender before you do that.
All right, so let's look at just a couple more things about trust planning.
Yeah. So I'm focusing on some of the things that you can do with the trust. One of the things is in particular, for example, if you have a situation where a person has a progressively debilitating disease, like for example, if you had ALS or something like this, trusts are particularly useful for that instance. For example, revocable trust. You could create a revocable trust where you are the grantor if you were sick, and then one of the things we always write into all of our revocable trusts is the ability of the successor trustees to take over the trust, the management of the trust. If the trustee, the grantor trustee, becomes incapacitated, and we write in, well, what the definition of incapacity is. And the beautiful thing about this is that when you create the revocable trust and you title assets in the trust, generally you give a copy of that trust to the institution, the financial institution or whatever you are placing the property into. For example, if you had a brokerage account and you wanted to title it in your revocable trust, you title it in, we'll just say it was the 2015 Michael J. Feinfeld Revocable Trust. If I title my brokerage account in it and I give a copy of that trust to my broker, then if I become incapacitated, my successor trustee is able generally to present evidence that that I'm incapacitated, and to step right in and manage and control those assets while I'm sick. Depending on the terms of the trust, they can do whatever I could. In particular, and maybe if I got better, I could take it over again, or whatever. But the important point is that this provides even more control over the assets than trying to do this through something like a power of attorney, where a lot of banks. There was a New York Times article recently that said that a lot of banks, in particular in the wake of the financial crisis, are rejecting powers of attorney. In particular, the ones that become operative upon incapacity, what we call springing powers of attorney here in New York State. So they're rejecting powers of attorney that whereas like for something like revocable trust, where they already have familiarity with the instrument, and they are and you're not presenting to them cold. For example, that provides a lot of protection against them discounting the instrument. So, sorry, go ahead.
No, I was going to say also when it comes to protecting loved ones and families, we mentioned like if you're bad with money, drug problems are often issues that people seek to help protect others from receiving large sums of money easily. But also a lot of people are concerned about possible divorces in their families in the future. They may have children that they want to leave their assets to, but those children are married and they're not certain that the marriage is going to last or that the inheritance will be protected. So they put it into a trust called a creditor protected trust or a spendthrift trust, so that creditors like a divorcing spouse doesn't have access to it. One of the main reasons my practice is divorce and family and estate planning. So a lot of my trust planning is because of potential divorces down the line.
Right. Yeah, well, I mean, it doesn't even have to be a divorce where you would protect a child. For example, if you have you can have a minor's trust. All my wills where you have the potential that a minor child will inherit will have a minor's trust in it, where you can't give money generally to a minor under the age of 18, at least in New York. And in certain instances, for example, if you have custodial accounts, it's age 21. But who wants their child really to get the property at age 18 or 21 even? Sometimes you wanted to keep them in trust and to protect the child from themselves. For example, they might develop a drug habit, as Brad mentioned, but they don't even have to. Maybe they're just too young to manage money. I know if I had come into a windfall when I was like in my early 20s, I certainly wouldn't have known what to do with it.
Right.
So that's one of what we build the trust usually into all of our wills, where minors have the potential of inheriting, because you want to keep that money out of their hands as long as possible. And in particular, when I was meeting with today, when I had a meeting with these people who run Delaware Asset Protection Trust, they were saying to me that they were telling me you want to keep in trust in money in trust as long as possible for a lot of people, because it's a great way to protect the assets from creditors, or just bad management, and a lot of times. And then
another question.
Sorry, go ahead.
Is it beneficial to have a trust for business assets? How are trusts affected differently from personal assets versus business assets?
Well, I think it's very useful to have a trust for business assets. In particular, you can build a trust into a will in a situation where it could hold assets at death, and then transfer the assets or sell them. For example, if it's in a case of somebody that isn't familiar with the business, it allows the trustee to manage the stock and the shares and things like that. Another example of that is if you wanted to gift assets. For example, if you had closely held corporate stock that generated a lot of income, a great way of gifting it to a family member, like say you wanted to give it to your daughter or something like that. She was active in your business and it generated a lot of cash. One of the ways you could do it is through what's called a grantor retained annuity trust. That's the way of where you basically, the person putting it into the GRAT for short, retains an annuity stream for a period of time, meaning they retain the income payments for a period of time, and that reduces the amount of the gift. And this is a great way, for example, because the grantor, because the person who creates it retains the ability to receive the income, and then it's taxed on that income. They can hold certain types of, for example, S corporation stock. That's a great way of gifting.
All right. Next, Michael's going to talk a little bit about elderly adult planning and special needs, usually children with special needs. The topics may take us a little over the time period that we allotted, so hopefully you'll stay online with us here and get the rest of the information.
Yeah. I wanted to talk a little bit about a couple of types of special needs planning. In particular, throughout, if you have a person, if a disabled adult, for example, or a child is receiving government benefits like Medicaid or SSI, for example, that if they receive any cash or any assets in particular, that could affect their benefits. So one way of preventing that from happening is the establishment of something called a special needs trust, and that has to be an irrevocable trust where the person that's receiving the government benefits is able to receive benefits from the trust assets without actually receiving the assets themselves. So the person who is designated as a trustee can purchase things or use trust assets to supplement their benefits without causing a period of ineligibility for the government benefits like Medicaid or SSI. And in New York, for example, the statute states that if a person who creates a supplemental needs trust with their own assets has to allow for the New York Social Services, the New York Department of Social Services to recoup amounts that are spent on their behalf from the trust. However, if you have a third-party situation, at least in New York, where the person is over the age of 21 and their relative or friend or whatever is creating a trust for the benefit of a disabled person on receiving government benefits, then they don't have to have that payback provision to New York Department of Social Services.
Michael, do you want to address that question that came up earlier about how do trusts maintain privacy while trying to qualify for long-term housing or care?
Yeah, I was gonna get to that. In particular, under the rules for Medicaid, they have a 5-year look-back period. That means that 5 years after you, they look back 5 years of your tax returns and your financial statements for 5 years after you apply for Medicaid. So if you potentially transfer property prior to 5 years to an irrevocable trust, in particular some form of an asset protection trust that limits the ability of the trust to pay anything to the disabled person who is applying for Medicaid or the elderly person that needs to go into a nursing home, then potentially you can get that out of consideration as an asset that's considered available for Medicaid, because Medicaid is a means-tested program where you're expected to spend down your own assets before you can qualify to receive it. And because it's in a trust and the trustee is not, presumably you don't want to be the trustee is not the same person that the assets are being transferred to it, that provides a level of privacy from the government and from anybody really finding out about it if you've transferred it before 5 years before you've applied for Medicaid.
But also remember, though, also that just because you transfer an asset within the 5-year look back doesn't mean that it's going to be reversed. There are legitimate reasons why a person will transfer assets. They have the right to look back and to possibly reverse or undo the transfer, but it doesn't necessarily mean that they're going to.
No, that's true. But they are looking for property at least to place a lien on it. And if you do transfer it within 5 years, it could create a period of ineligibility, a period where you would have to at least pay out of your own pocket for the cost of whatever your care would be that you were trying to receive. So, for example, if you're applying for a nursing home, they're going to take the fair market value of the assets that you transferred into that trust, and then divide it over the cost of the care, I believe, per month, to create a period of X number of months when you're ineligible to receive Medicaid under that. So, unless you have enough assets to cover the fair market value of the asset that you've transferred into that trust, then you're not going to be able to receive Medicaid, and in any ways you're going to have to come up with the money to pay for the care. Okay. So one way that revocable, talk a little bit about a retired couple with, you can use, who are applying for Medicaid, can use a trust, they can use a revocable living trust to help manage their affairs. In particular, if they have, a home, like, for example, a vacation home, or even, because of the rules under Medicaid, if you have home that you live in, your domicile, that's not considered an available asset necessarily. So in New York, I believe the amount that of equity in your home you're allowed to have is $828,000. I don't know what it is in New Jersey. Do you know what it is, Brett?
No, actually not offhand.
Okay. But using a revocable trust can help, as I mentioned before, allowing somebody to step in and manage a person's affairs or business if they become incapacitated. It can avoid probate. In particular, it can avoid an ancillary probate, probating the will outside another jurisdiction outside of the jurisdiction of domicile, but also it can avoid a Medicaid lien on, for example, property that passes outside of the estate. Because under the Medicaid rules, I believe that they can place a lien on probate property, but because of assets in a revocable trust passed outside of probate, it's not probate property. So that's one way that you could potentially pass your home or outside of your estate and protect it for Medicaid purposes. On the other hand, if you transfer it within 5 years, they can see it. So then they might be able to try and claw that back. But this answers the question that I posed before, which is how can we combine the benefits of a will, a durable power of attorney, healthcare proxy, living will, into one document. Well, the revocable trust is a very powerful way of doing that because it allows your trustee to step in the event that you become incapacitated. It provides the function of a will substitute that passes property upon the creator's death. And also, it allows the trustee to manage the business assets that are at least in the estate while the grantor is alive.
All right, last, Michael's going to talk a little bit about children with special needs and planning for those.
Yeah, okay. I really kind of mentioned this before when I was talking a little bit about supplemental needs trust, but basically, you don't want a child or an adult who's receiving government benefits to receive that property from a will or from an estate or anything, or by gift outright, because the settlement or even a personal injury settlement can knock a person off their benefits. Fortunately, under both federal and New York law, you can set up an irrevocable trust known as a supplemental needs trust, which allows the trustee to buy things or make payments, not directly to the beneficiary, but make payments in support of this person who is disabled on their behalf, and to help provide a better lifestyle for the disabled person receiving government benefits. The only thing is that they have to be drafted properly. So you want to have an attorney who's familiar with drafting supplemental needs trust help you. In New York State, there's a specific rules, and you have to if you're creating a self-settled, meaning that it's the disabled person's assets, you have to allow the New York Department of Social Services to receive the money back to get that they spent for the cost of care on the disabled person. But as I mentioned before, your third party can create it. Can create one if they don't have any obligation to support the disabled person without providing that ability to pay back the state.
Let me jump in and correct something. So when I introduced the topic I spoke of special needs children, but this is actually both for adults and children. And with the self-settled trust that Michael referred to, self-settled trust means if you are an individual that has an injury or special needs and you're receiving governmental benefits, and you yourself want to establish your own special needs trust so that you don't lose your benefits if you are coming into money or inheritance or a settlement, you would create your own. In New Jersey, I don't know if it's the same in New York, you actually need to get court's permission to create one. So you have to file in the civil part in the court with the form that you intend to draft or the trust that you intend to utilize. The court has to approve it before the money will actually be sheltered.
Yeah, well, you do with regard to personal injury settlements and things like that. Yeah. Yeah. I believe he can set it up otherwise for like a gift or in their will or something like that. But
All right, so let's look at just a few more other characteristics before we wrap up for tonight.
yeah. So planning for a disabled. Oh, yeah. These are the in order to create the trust for the person who is disabled and receiving government benefits, they can be established with if certain criteria are met. Basically, if the person is under the age of 65 and they're disabled, if it's created, for example, with only their pension money or Social Security, if it's managed as a pooled by a pooled funds, these are often done by not-for-profit groups or charities, and it contains a clause allowing the state Medicaid or SSI to be reimbursed for the cost of care, and those are the specific criteria under federal law for establishing what I call the self-settled supplemental needs trust. And as I mentioned before, you can have the irrevocable trust where the person doesn't have an obligation to support with a third party irrevocable supplemental needs trust. In particular, the trust is set up by the person who is not the disabled person for the benefit of the disabled person, and they don't have an obligation, the person setting up the trust, to support that disabled person.
Another thing to consider when you're looking at, especially when it's a child that has special needs, a lot of families will look only inside their family and their asset structure to determine if there's a need to create it. But you need to consider that your child may inherit from somebody else in your family at some later point in time. So if you have a child or even an adult that was your child that has special needs, you should consider a special needs trust, even if you don't anticipate passing assets yourself, just as a means of protection in case they do end up later coming into a large sum of money that you didn't anticipate.
Yeah, absolutely. And you can have somebody's will pay over additional amount to a supplemental needs trust that is established, by somebody else. I mean, the supplemental needs trust doesn't have to be static; it can accept new assets too. So that's particularly if it's drafted that way in order to set that up. So, I mean, it's a very powerful tool, and it prevents really from there being a gap in the care that of the person who's receiving government benefits. It's very important.
Okay. We have also a question on this issue. What are some of the specific items which can be purchased for the beneficiary without violating the benefits received by them?
Well, I mean, if you want to buy them, clothes, if they want to, buy them food and things like that, I believe that they can do that without violating too much. I mean, the basic things they can buy them books and videos and televisions and things that make their lives better, essentially.
Well, I think the way they were, and it's a little confusing. So whenever I do it, I print out and hand to my clients the terms, because I think it's actually, and it seems ironic that you can't give money for like food, generally for food, clothing, or shelter, any of the needs that are being provided for by the governmental benefits. So you have to look at what are the benefits being received in place of before you can actually determine what can be purchased under the special.
Right.
It's always a complicated analysis, but more importantly, you don't necessarily lose your benefits because items were purchased out of this funds and the special needs. The beneficiary picks it up as income, and the income could cause them to lose some of their governmental benefits. So the trustee needs to really balance what is the need that the trust will fill against what is the loss of potential income, because you may be able or need to buy a more suitable housing, and it may affect some of the benefits, or their governmental benefits, but the benefit to the individual is greater than the loss of the income. So it's almost a case by case analysis to whether or not you will use it in a way that does cause a diminution of their benefits. Doesn't mean it's prohibited. It just means you have to analyze if it's worth it or not.
Right. I mean, but I mean, there's actually a new program out now where you can create a 529 plan for a disabled person as well. That's the 529 ABLE program. It was just enacted in law last year, and that is actually more restrictive than a than a supplemental needs trust. That in particular has like you have qualified higher education expenses, that has qualified disability expenses, and that has specific things that you can spend it on. For generally, I mean, as long as you are within not actually giving the disabled person money or in particular assets, you can generally purchase a lot for them.
All right, so we tried to answer most of the questions. I think we got all of them, but we will still take a minute or a few minutes if there are other questions anybody wants to pose. We're here as long as you need. There is one question. What is the 529 for disabled individuals called?
The 529 ABLE plan program. It hasn't been established. I don't know that it's been established. It hasn't been established here in New York. From what I know, the only jurisdiction that I know for a fact that they've actually passed legislation on it is Virginia, but it's coming. It's coming quite soon, I believe, when more jurisdictions pick it up. I mean, the IRS just last month published regulations regarding how the programs are to be administered. So they're just figuring it out now. But from what I understand, it's going to be an additional means in which you can create a benefit for people that are disabled receiving government benefits.
All right, like I said, any other questions? We're here as much as you need. All right, I don't see any. If I happen to be cutting you off, feel free to email either me or Michael. Our information is right here. I want to thank Michael for taking his time out of his busy schedule to talk with us tonight, give us this information. I hope it helped everybody as much as it did me. And with that, I wish everybody a good night.
Yeah, thank you.